Good afternoon to everyone joining us from Asia, and good morning or good evening to everyone who's joining us from different time zones. My name is Christian Hoffmann. I'm the Deputy Director of the Center for Asian Legal Studies. And on behalf of the Center, I'm pleased to welcome you all to this webinar on critical reflections on international law, justice, and the Global South, which is co-organized by the Center of Asian Legal Studies and the Center for International Law here at the National University of Singapore. Today's webinar is in fact a premiere because it is the first event that comes under our newly created International Law in Asia speaker series, and the first event that is attributable to our new CALS research cluster coordinated by my colleague, Professor Chair, on international law in Asia. And since it is so new, I would like to say just a few brief words on this new cluster. So this International Law in Asia cluster aims to generate cutting-edge international law research and knowledge by facilitating exchange and collaboration among NUS researchers and the larger international law community. It aims to be an inclusive forum for the discussion of international law issues, particularly in the Asian context, among international law researchers, practitioners, and policymakers. The cluster's activities will draw on the NUS law faculty's expertise across public and also private international law in pursuing the study of significant and timely issues. It intends to function as a hub that brings together and showcases the NUS law faculty's international law research and collaboration with other international law actors. The new cluster complements our list of existing research clusters which focus on comparative civil law, comparative commercial law, comparative public law, and law and religion in Asia. And these now 5 research clusters regularly organize events, and I hope to see everyone who's participating today again for our other events. You're cordially invited to join us for these events in person or online. Before we now start the talks, I would like to thank my colleague, Professor Chua, for taking on the lead role in this new cluster and for organizing and moderating today's International Law in Asia Speaker Series event. I would also like to express my gratitude to our speakers, Judge Pangalangan and Professor Oral, for joining us today and for providing their views and insights on this important and interesting topic. And for this, I'm now inviting Professor Chair to moderate the webinar, to take over for me and to introduce today's speakers.
Thank you very much, Professor Hoffmann. It gives me great pleasure today to be moderating this seminar, which also serves as the launch of the NUS Law Center for Asian Legal Studies International Law in Asia cluster. The seminar explores challenges that the Global South faces in international law. While many believe that the international legal system has become more inclusive and equitable, others highlight the continued structural inequalities within international law and the marginalisation of Global South voices. Has international law generated positive change and justice for the Global South? To what extent has international law accommodated the perspectives and needs of the Global South? These are some of the questions that our speakers will be addressing today. We are truly honored to have with us Judge Raul Pangalangan, who served as a judge to the International Criminal Court from 13 July 2015 to 10 March 2021. During his tenure, he also served as president of the Trial Division. Our other speaker is Director Niloufar Oral, who is member of the UN International Law Commission and co-chair of the study group on sea level rise in relation to international law. She currently also serves as the director of NUS Center of International Law. We have asked them to speak on the theme of international law, justice, and the Global South, drawing on their academic expertise and extensive experience in international law institutions. Our speakers have agreed to speak about 15 to 20 minutes each, and that will leave us ample time for discussion. So we really look forward to an active audience engagement. I will now pass this over to Judge Pangalangan.
Thank you. Thank you so much, Chair, for the very kind introduction. Thank you to Christian for opening the the forum, and I'm glad I have the chance to work once again with Nilofer in this panel. Okay. The central point of my presentation is that we have usually seen the North-South divide as a clash at the international level between countries of the global North and countries of the global South. And what I propose this afternoon is that since the era of decolonization, things have changed fundamentally, such that the North-South divide has been internalized within countries in the global South. In other words, what was before seen as a clash, perhaps geographic, perhaps at the level of nation states, can be seen, has been replicated domestically within the erstwhile third world states, which are then divided into elements of the global North within a third world state and elements of the global South. I have heard it mentioned, in fact, that the elites in third world states will have more in common with elites in the first world states. They have more things to talk about. They have more common interests. Even their language will be shared. And these third world elites will have less in common with their own fellow natives, with their own compatriots who belong to the poorer classes. Okay. And since this is an international law forum, I propose that this shift is actually reflected in our treatment of international law doctrines. Okay. My point of reference for explaining this will be the high water mark in the articulation of the interests of what today we now call the Global South. That is the Bandung Conference of 1955. The Asian African Conference, which convened in Indonesia and which brought together the biggest names of the decolonized nations: Chou Enlai of China, Nehru of India, Nasser of Egypt, and Sukarno of Indonesia, and countries from some 25 other states, newly independent states. As you can imagine, the Bandung principles articulated the international law favored by the newly independent states. I will now read out to you verbatim excerpts from the speech of Sukarno, the opening speech, because it captures the full rhetoric of that period, which I think we have to remind the younger generation today that this was the rhetoric of that era and should reflect the passion and, of course, the aspirations of that generation. He says, "For many generations of our peoples have been voiceless. We have been the unregarded, the peoples for whom decisions were made by others whose own interests were paramount, the peoples who lived in poverty and humiliation." And then he says, "And today in this hall we are gathered as leaders of the same people, no longer victims of colonialism, no longer the tools of others, no longer the playthings of forces they cannot influence. We are representatives of free peoples, peoples of a different stature and standing. The contrast is great. Our nations and countries are colonies no more. Now we are free. Now we are sovereign and independent. We are again masters in our own house." So, as you can imagine, for this kind of a rhetoric, the holy grail will be the principle of sovereignty, the principle of self-determination, the principle of respect of the non-use of force against the territorial integrity and political independence of states. Okay. How does this kind of aspiration translate then into international law? Let me review a few of these principles. The big fight then for the North-South debate would find itself manifested in the debate on expropriation of newly independent states whose natural resources were locked into concession agreements with corporations based in the former colonizers, in the capitals of former colonizers. And the debate on expropriation will then express itself in certain documents. Nilofer would be more familiar with this at the International Law Commission. The drafting of the Articles on State Responsibility was tied up for several decades. It went through several rapporteurs, from Garcia Amador all the way to the final draft, which was approved under James Crawford. Because it was in the Articles of Incorporation that the debate on the breaches of international law obligation, and at that time the main breach, well, which was threatened by the newly independent states, was that of expropriation. And the document moved forward only when they adopted Hart's distinction between primary rules and secondary rules, such that they were able to avoid altogether the substantive debate on whether states, the newly independent states, had the right to expropriate foreign investments and separate that from the secondary rules on enforcement. Conversely, the backlash from the Global South will be the term permanent sovereignty over natural resources. Professor Abi Saab from Egypt, in fact, said in a lecture that if someone from outer space came upon this doctrine, he will ask, well, why not just sovereignty over natural resources? Why not just sovereignty? Why add the word permanent? And he said, because the backdrop of the entire doctrine was to say that these newly independent states retained their sovereignty over natural resources and were not and had not bargained away that sovereignty through these concession agreements. So notice, we are talking about the North-South divide, and if we discussed it at that time of history, the 50s, the 60s, this is how it would have been expressed. It would have been expressed as well in the principle of the non-use of force, the principle of non-intervention in domestic jurisdiction of states, and the high watermark for that development is the case of Nicaragua versus United States at the ICJ. And when the Reagan government in the United States tried to destabilize, I imagine, hopefully overthrow the left-leaning Sandinistas in Nicaragua. And the court found jurisdiction and ruled against the United States, declaring that the non-use of force and non-intervention principles were violated and that they were actually norms of customary international law. Another arena for the North-South divide in international law was the rule of the interpretations of sovereign immunity. And this time it was the global North reacting to the rise of socialist states, such that had they retained the traditional interpretation of sovereign immunity, state corporations from these socialist states would have enjoyed immunity. And that gave birth to the theory of restrictive immunity, the distinction between iure imperi, acts iure imperi, and acts iure gestionis. And finally, if international law were to be debated by the North-South, were to be situated in the North-South divide at that time, the debate on territory would have emphasized the principle that of territorial integrity, the principle that self-determination may not justify secession, and the principle, ironically, of uti possidetis, the sanctity of inherited colonial boundaries, even post independence, a principle that has been invoked before the ICJ, in fact, for states in Southeast Asia. Okay, what is the shift that I speak of It is actually anticipated in the speech of Sukarno in Bandung. He says, "I beg of you, do not think of colonialism only in the classic form that we knew." He says, "Colonialism has its modern dress in the form of economic control, intellectual control, actual physical control by a small but alien community within a nation. It is a skillful and determined enemy, and it appears in many guises." End of quote. I imagine he was referring to what eventually will be called the divide between the capitalist metropolis in the former colonizers' states and the periphery in the former colonies. But I would like to see the distinction that he makes, the modern dress of colonialism, in the rise of third world despots who were no worse than the colonizer, and such that we end up with the irony that the international law mechanism against these third world despots will actually be interventionary mechanisms under international law. And such that what we have is that if the holy grail of the old debate in international law, if the holy grail was sovereignty, the progressive international law will entail erosions of sovereignty or transcendence of sovereignty. And I will now give some examples. The subject of peoples, the concept of peoples as a subject of international law, distinguished from the Westphalian nation state. The attribution of self-determination to subnational entities like indigenous peoples. The recognition of wars of national liberation as international armed conflicts under the additional Protocol 1 of the Geneva Convention, such that these struggles, which under the old law might have been considered as internal conflicts, as mere civil wars, would be elevated to an international level because of the causes of the struggle against colonial powers and racist regimes. And Abi Saab refers to this as the poetic justice of their internationalization, when he says that whereas before the colonizer subsumed their colony within their domestic law and transformed the erstwhile international relationship into a domestic relationship. He says that with the War of National Liberation concept, then we recognize what was originally the international struggle as properly international, without being bound by the old law that it should be considered domestic. The same thing with the notion of territory and of natural resources. We have now emerged with the concept of the common heritage of mankind. And of course, the familiar story for most of us, the law of human rights allows the international community to regulate the relations between states and their own states of nationality. In terms of sources of international law and the enforcement of these obligations, we have emerged with concepts that effectively override the jealously guarded prerogatives of sovereignty. Hugh Scoggins, for instance, Hugh Scoggins norms are applauded these days. And yet the fact is, the concept of Hugh Scoggins will be hard to reconcile with the original Sukarno rhetoric on the primacy of sovereignty and the consent of states. The same thing with modern interpretations of customary international law. The same thing with the notion of erga omnes. So in the case of the ICJ on East Timor, it was the former colonizer that raised their claim to self-determination before the ICJ, citing that it was an erga omnes, citing the erga omnes character of the right against the right of self determination. So, just by way of closing, even in Bandung, they already recognized that this is not a matter that belongs solely to Asia. Sukarno says, we cannot confine our interests to the affairs of our own continents. The states of the world today depend upon one another, and no nation can be an island unto itself. Splendid isolation may have been possible once, but it is no longer. And he says, so what can we do? And he says, the peoples of Asia and Africa wield little physical power. Even their economic strength is dispersed and slight. And by the way, on that part, by 2023, the economic strength of Asia has grown. But he says, we cannot indulge in power politics, and diplomacy for us is not a matter of the big state. What can we do? And he says, we can do much. We can inject the voice of reason into world affairs. We can mobilize all the spiritual, all the moral, all the political strength of Asia and Africa on the side of peace. Well, of course, that is at the level of high rhetoric. Just by way of closing, for me, the interests of the global South today must go beyond the traditional formula of us versus them, the global South versus the global North. That might be viable still on questions like climate change, where the rhetoric packs a lot of power. But in many others, I think we have to come to a point where we hold accountable the elites within the domestic jurisdiction of states in the global South, and ask to what extent they have perpetuated the depredation and the oppression that they were supposed to have combated when they fought colonialism, and the way they have brought it back, even worsened it in the post-colonial era. It is the erosions, therefore, of sovereignty, the erosion and also the transcendence of sovereignty. That, for me, will be the key to the international law interpretations by the global South. I'll close on that point. Thank you.
Thank you very much, Judge. That was a really interesting presentation, especially your call for the need to relook strategy in terms of addressing issues of justice. I will now pass this on to Dr. Aurel for her presentation.
Yes, thank you. Thank you so much, Professor Che and Professor Hoffman, for this invitation to speak on a really, really interesting, important, and topical issue, actually. I think there is a lot of discussion now. We hear a lot about the Global South. And I congratulate you on this series, and really very honored to be in the inaugural one, and especially with Judge Pangalangan. So it's really, for me, a great privilege. And thanks to all who are joining us. I have to say, that was a great lecture, actually. And I was particularly taken by the conclusion in terms of taking the issue of the Global South, how it began, and its domestic phase right now. I'm hoping to complement this lecture and looking at the issue of this Global South, international law, and I guess looking at it within the context of some of the questions that you posed. Has it changed? Is it the system more inclusive for the Global South? Speaking about international law, of course. Do the structural deficiencies still exist? And what I thought I would do would be to look at international lawmaking from the context of international lawmaking. But one thing I want to say, and I was doing a little research because I'm not an expert on the Global South, but is that the term Global South actually was coined by someone from the Global North back in 1969, apparently. And this was in relation to Vietnam. So I think that's something interesting, that if that's the case, we have indeed in the Global South adopted what is a Global North terminology. So this is something to think about. So this period, when the Global South, of course, the key period is the decolonization period. And so what I'm going to start off is looking at what influence did the Global South have in international lawmaking. And I've selected just a few areas to look at where I think the influence was significant. And one of the first ones, in fact, Judge Pangalakan has already addressed, and that is a very important principle of permanent sovereignty over natural resources. And this was a principle that emerged in the post-World War II era, starting in the 1950s, but it's the 1962 General Assembly Resolution 1803 that declared the right of peoples and nations to permanent sovereignty over their natural wealth and resources must be exercised in the interest of their national development and of the well-being of the people of the state concerned. And there were many more resolutions that followed. And in fact, the principle of permanent sovereignty over natural resources has been reflected in different instruments, and it has been also accepted as customary international law. And most recently, we see this was confirmed by the International Court of Justice in the armed activity case between the DCR and Uganda. But bringing it up, its application in another area, for example, Nagoya Protocol to the Convention on Biological Diversity. Again, the importance is, as was already stated, it is the principle that the state's sovereignty, permanent sovereignty, that is control and rights over their own natural resources. And this was something that became an issue with access to genetic resources. So this developed the principle of prior informed consent, meaning that prior informed consent would have to be obtained in a country in which the genetic resources were located. So again, it is reflected in many other instruments. Second, and I think this is one area where we really see the voice of the Global South extremely strong, influential, and that is the area I do a lot of work in, the Law of the Sea. So the current Law of the Sea Convention was actually succeeded another convention, which is the 1958 Geneva Conventions. There were 4 of them. And those 1958 Geneva Conventions, of course, were based on the work of the ILC, the International Law Commission, which is a small group of experts, later negotiated by states. But at that time, many states that belonged to the Global South were absent from the negotiations. The 1982 Law of the Sea Convention is significant for many reasons, but perhaps one of the most important is that it is the first international multilateral convention, and is a very important one that was heavily influenced by the interests of the Global South, starting with its whole initiation was by Malta, famous Ambassador Arvid Pardo. And at the time, Malta was part of the Global South. It was a poor country. Now it's part of the EU. It's changed. And what launched the Law of the Sea Convention was the concern that the rich developed states would have the ability and capacity to access deep sea minerals, and that the poor nations, the developing world, would once again be left behind. And so this launched what became the Law of the Sea Convention, 9 years of negotiations. And I'm just going to pinpoint some of the important aspects of it that were very much in the interest of the Global South. the exclusive economic zone. So until the Law of the Sea Convention, you had basically internal waters, territorial seas, and the high seas. The high seas is an open access regime, freedom of navigation, freedom of fishing. And who did that benefit? The rich countries. It was the proposal of Kenya coming out of the Asian African Legal Consultative Organization that the exclusive economic zone concept was introduced. This was very important for the Global South to be able to control and have jurisdiction over the natural resources of the marine environment. At that time, really fisheries. So the exclusive economic zone was very much in the interest of the Global South, and it came from the Global South. As already been mentioned, the common heritage of mankind. This was what Ambassador Ardo Parvati had proposed, saying that the deep seabed was the common heritage of mankind. Although this concept, the principle, existed already in the context of space, actually, the Law of the Sea Convention has the only very detailed regime for access, sharing, and importantly, benefit sharing. And this did become an issue with the globe, particularly with the United States, but the Global South was absolutely adamant in maintaining the common heritage of mankind. Some amendments were made later on, etc. I won't go into the details, but the common heritage of mankind is very much the Global South. Now let's go back go forward some decades. We now recently had another convention, recently adopted under the Law of the Sea Convention. That's what we call BBNJ. Basically, it's a new agreement for the conservation and sustainable use of biological diversity in areas beyond national jurisdiction. Way too long. It also includes, however, access to marine genetic resources. And the big debate during the negotiations that was launched by the Global South, we can say, was that those the marine genetic resources in areas beyond national jurisdiction were part of the common heritage of mankind. So this was a debate. In this case, they were not able to incorporate it within the regime under Part 11. However, it was still recognized as a principle, so kind of a compromise. So we see that these issues continue to resonate. But one other aspect I want to highlight about the Law of the Sea Convention. Who were the negotiators? Who led? Who were the leading names? They were all from the Global South, in particular, Asia. Shirley Amarasinghe was the first president from Sri Lanka. He was then followed by Tommy Koh from Singapore. And a very prominent name was Satyanandan, Ambassador Satyanandan from Fiji. There is no question that the Law of the Sea Convention was very much influenced, very much where the voice of the Global South was heard loud and highly significant. There are other aspects too, but I don't want to take too much time. And I suppose now looking at, this was a period in this is the post-colonial period, 1970s to 1982. And I guess my question would be, was that the peak of the influence of the Global South and multilateral treaty making? Or has it continued? And I can't answer that question, but it's something that we can think about. Another area, and this is related to climate change, but it's also in other instruments as well, but the principle of common but differentiated responsibilities. This is very much a principle, it's a principle of environmental law, and it very much recognizes the interests of the Global South in that the industrialized, rich Global North, as we call it, they were able to develop at the expense of the environment. However, environmental law, protection of the environment emerged, and the question became whether that would be a burden, of course, on the right of development of the global south, the developing countries. So common but differentiated responsibility, this principle recognizes the historic responsibility of the developed countries, and that the developing countries, in their right to develop, did not have to assume the same responsibilities. This was reflected in Principle 7 of the Rio Declaration from the Rio Earth Summit, but importantly, it was codified in the climate change regime in the United Nations Framework Convention on Climate Change, the Kyoto Protocol, which frankly really made very clear the difference between the developed countries and the developing countries. The developed countries were, it was a bifurcated system. And so the developed countries were required, one, to take on clear commitments for emission reductions. And if they failed to, there was actually enforcement measures and also financial obligations towards the developing countries. But what's interesting, and this is why when we think about, what has happened in this period, in 2015, so the United Nations Framework Convention was in 1992. So it's 10 years after the Law of the Sea Convention. The Paris Agreement is in 2015, and that changed everything. Under the Paris Agreement, the bifurcated system was really diluted very much. And why? Well, it wasn't the same global south. And I think that's one of the issues that we have to look at. The global south, during the decolonization period, 50s, 60s, 70s, even 80s, up until the 90s, more or less homogenous in their economic development. But that changed. We have China emerging, we have Indonesia, Brazil. These countries became known as major emitters in terms of climate change. There was development. Singapore is an example of a country that was once poor and really is now a very developed country. So one of the challenges is who belongs to the global south? Are their interests still the same? And this is why the Paris Agreement ended up changing the structure, where moving away from that bifurcated system, it established, they call it a bottom-up, but essentially what it requires is that everyone, according to their capabilities, still the developed countries are to take the lead, have to undertake emission reductions. And now we're all looking towards the net zero pathway. So I have to be careful about the time. So these are some of the treaties, the instruments where the Global South has been influential in my view. But I also want to touch lightly upon, can I ask how much time I have? How am I doing?
Yeah, you're on time. I think you're on time. You have around 5 minutes.
Okay, good. So I'll wrap up with last observations. I just want to touch upon also, so those were some of the instruments of international lawmaking, but who's actually making these, the representation? And I thought I would give the example of the International Law Commission, which I'm a member of. So the International Law Commission has the mandate for the progressive development of international law and its codification. It's a subsidiary body under the General Assembly. It was established in 1947. And it established the foundation for many, many treaties. And I have to say, when it was initially established, it had a membership of 15. And eventually that was broadened. The current membership is 34. Very important that in 1956, and this is the decolonization period, it took into account regional representation. So now today, out of the 34 members, 9 nationals are from African states, 8 nationals from Asia, 3 nationals from Eastern European states, 6 from Latin American, Caribbean, and 8 from Western Europe and other states, which includes Australia, United States, New Zealand, Israel, and Turkey. So what that means is that the majority of the members of the Commission are from countries that would be deemed to be the Global South. What's interesting, though, is that in a study, most of the special rapporteurs have come from the Western European other states. That is basically the developed country states, the global north. And the question is why? And I ask that because the decisions are taken internally by the Commission as to what topics will be chosen, who will be special rapporteur. So it's interesting that in that where the majority are actually from the Global South, it's still we see the developed country group, one region, still tends to dominate. So it's something to think about. And there's one issue that we also have to look at, has to do with capacity as well. And this is something, again, it comes up within the context of the UN International Law Commission, and that we note that, again, it's mostly the global north that provide information and feedback, and the global south tends to be, less active. And this is a question of capacity. So how do we address this capacity deficit? Meaning that there's a need for more, they have small missions, smaller number of legal experts. What about the role of regional legal bodies, such as ALCO, the Inter-American Juridical Committee, the African Union Commission on International Law? These are also important bodies for bringing the influence and voice of the Global South into international law making. So I have many more questions and issues to discuss. It's such a fascinating topic, really. But I want to end on one example, and that's from the work I do on sea level rise. The Pacific Island states are probably the most vulnerable, small in population, large in ocean space, very economically disadvantaged. But they have demonstrated how collective and focused approach, strategically using the multilateral UN system, they can really have a very big voice, and how they can influence the UN system as they have with sea level rise. To me, it is an example of how the Global South can use that system to have their voice heard. So I will just stop here because I may have gone over time. Thank you so much.
Thank you so much, Dr. Aurel. That was really fascinating. And I just couldn't stop taking down so many notes. And I think that one common theme that you and Judge have pointed out is the changing nature of the Global South. So now we have entered into our Q&A session, and I want to encourage our audience members to please post questions in the chat, and I will read out the questions. And please don't be shy. Please post the questions, and I will start off as moderator, and drawing on this theme that came out in both your presentations about the changing nature of the Global South. And I was wondering, given all these changes, what purpose do you think this term or label still has? Does it still have any use as an analytical label or as an organizing label, and how? Or should we be describing groups or states in another way, in more context-specific ways? Maybe Dr. Aurel?
Yeah, thank you. It's a really good question. And my sense is that the Global South was, I would say, a homogenous group in the decolonization period. But I don't think we can say that anymore. The countries are at different levels. And you have those, now we make the distinction between the least developed countries, developing countries. There's all these different gradations. And the interests are different. So I'm not sure that when we talk about the global south, who are we talking about exactly? Are we talking about the most vulnerable? Or does that include China, Indonesia? You know, these are big countries, actually. India, yes, global south, but they're big and powerful countries, unlike some of the much smaller countries. Do they represent their interests necessarily? I don't know. But I think when you look at negotiations, and that's why I look at it from the lens of negotiations, you know, they have regional groups in negotiations, and there's so many of them, but the biggest one is the G77 plus China. And so I'm not sure. I understand that sometimes the weakest voices aren't necessarily heard. So within the global south itself, I'm sure there are inequalities. But this is something perhaps a judge can talk about, because I think his point, I really think it's a very important point he made, and I agree with that at the domestic level.
Let me try to answer. It's a tough question that you posed to us, Chia. And I share Niloufer's well, guarded, position on the continuing relevance of the concept of global south. So let me just survey. The term third world, the term global south, I think the danger is that they don't mean much analytically, but they can be exploited rhetorically. And that's my chief problem. I mean, which goes back to my concern about third world elites, cloaking themselves with a banner of the global south, when actually they don't experience the southness of they don't experience the poverty and the misery of their countrymen. So for me, it's this: the concept of for the decolonized states, which was, by the way, the unifying concept for Bandung of the Asian and African states. Well, I think we are now, I would say, half a century away from decolonization. And I think it is time to for these former colonies to own up for the parts of the problem that they inflicted upon themselves, and that, which means that it wasn't a problem inherited from the colonizer. So I think the lapse of time is one factor. The concept of the decolonized state is increasingly not useful analytically. Now, the other thing is, maybe by global south, it is simply a statement of the economic and social condition of these states. And but I think if to that extent, as you have noted, Chia, I don't think China, I mean the BRICS states, have actually organized themselves as a separate category, and for them to be lumped together with the developing states, I think is inaccurate, and might even be just as I've mentioned, a strategic move by these states to find allies for their own causes. So my conclusion, Chia, is the conceptually it is not that useful. Although I do recognize what Niloufer said about the negotiations on climate change. As I noted earlier, the problem really is not something which arose overnight. It arose over a whole century of abuses of the environment, and a good part of that century, and a good part of the benefits from that exploitation was redounded to the global north. So I think it is relevant for that aspect, but not for others. I'll close on that point, Chia.
Thank you very much. We have a couple of really good questions from our audience. So I will start with the first one from Fred Lubang. He talks about how the history of colonialism continues to influence the relationship between international law, justice, and the global south. Many international law norms and institutions were established during the colonial era, and to serve to protect the interests of colonial powers. And he gives an example. The weapon system has been one of the sources of colonial power until today. Compliance to weapons-related treaties is reflective of these power dynamics. And new weapon systems will be developed, but will still favor former colonial powers or new powers that are going through a decolonization process. So how do the speakers envision a decolonized international law?
Should I?
Yes, Judge, could you go first since Dr. Orel went earlier?
It's difficult. I know that Fred is writing his PhD on this topic, so I think he knows much more about weapons systems. But you know, I go back to the Bandung, what I call the ironies of Bandung. At that time, they already recognized the threat coming from nuclear powers, and yet the irony today is that many of those present in Bandung many of the states represented at Bandung are actually nuclear powers themselves. Now, as regards new weapons systems, I'm not familiar enough with them. Fred says that they are, I suppose, they originate from what we will call the global north. But from what I've read, sure, they're invented by the global north, they're sold by the global north, but I imagine many of their buyers and customers are actually from armed groups in the global south. So I don't know to what extent we can draw we can situate that the access to these weapon systems within the north-south global divide.
Yeah, I guess I'll follow on that. Very thought-provoking question, of course. And I have to say, so, yes, it's true, but, decolonization's been at least 50 years now. And I think what I was trying to do, and I have to tell you that preparing for this really has got me interested in this topic a lot, but is to look at from that perspective, how in the post-colonization period, the global south, which is the majority in the General Assembly, that's what I was saying, is the majority in the International Law Commission. The global south has a lot of power in numbers. So why is that not reflecting then in the norms of international law, the rules of international law, the treaties of international? It did. I mean, that's why I was showing the Law of the Sea Convention, the climate change, the principles, common but differentiated response, all of these, global south. So the question then is, what is decolonization of international law? I have to turn the question around. What are the values of the global south? I've been asking myself that. The only thing I hear has more to do with economic development, but are there other values? Environmental protection comes up immediately. Oh, but we have the right to develop. Well, you're not going to have much development if you're burned up by climate change. And yes, of course, the global north is important, but let's be honest. There are some, big developing countries, maybe they're not even developing anymore. So what does international law mean to the global south? What are the values? Even though we can criticize maybe the double standards and hypocrisy of the global north values, we know what they are. Whether it be human rights, whether it be freedom of expression, things like that. But I think, so I have more questions than answers, to be honest.
Thank you very much. The next question is from Andre. Andre is asking, could the speakers reflect on the accessibility of the international legal profession? I think this is a very relevant question. For example, many international organizations and courts rely on unpaid internships, which tend to disproportionately exclude law graduates from the Global South compared to better resourced counterparts in the Global North. This often forms a pipeline into international organizations, allowing them to shape institutions and lawmaking. How can we best approach this accessibility gap? And I think this speaks also to Dr. Orrell's concerns about capacity building, given the overrepresentation of global North perspectives and personnel at many levels in international legal institutions. Perhaps Dr. Orrell, you could start first.
Yeah, that's a really important point raised by Andre. And it is very true. Again, I'll give the example of the International Law Commission because we see it there, we talk about it. And in fact, we are trying to address that where we know that, for example, NYU, George Washington, the American universities in particular, are able to send students to be interns. And they I mean, they may not be staying at 5-star hotels, but they're able to at least have accommodation and live in Geneva, which is an expensive city. However, rightly so, you don't, I mean, it's much more difficult for the Global South. But I will say this, though, and it does come to the point that Judge Pangalagan was making as well. You know, the Global South, I mean, depends which countries, though, because they're not all the same. Some are really poor, don't have money. Some have money. They choose to spend it on weapons. They could actually spend money on capacity building for their own legal expertise as well. So I think to lump it all within the responsibility of just one group is not reflecting the reality as well. But it is an issue. It's really important. And for example, the ICJ, they established a fellowship program that now is a trust fund for that. And they're addressing it by being able to bring in ICJ fellows from developing countries as well. So it's very, very important because we really need to build that capacity. As we know, one issue is, and again, in international law, the international lawyers are all coming from Europe and America. Why not, you know, from other parts of the world, particularly developing countries? So it's very important. We need to really find some solutions to that. But I think we also have to look within as well. You know, do the Global South countries who can put aside a little bit of money for this, why aren't they?
Well, Chair, may I answer now?
Please, yes.
I confirm Nilofer's experience in the ILC can be confirmed also in the experience of the ICC. In the early days, there were paid internships, and then the fund dried up, and people were concerned that unless there are funded internships, the interns will be those young lawyers coming from Europe, and for whom, to start with, apprenticeships are part of their educational licensing processes, and that eventually, and as Andre mentioned, that these internships contribute to the pipeline for jobs eventually. It is almost a guarantee that eventually the staff of the court will be mostly from Europe, and therefore defeating the nature of the court as an international tribunal. So it is a real problem. Well, I'm so glad Nilofer mentioned the priorities of the states themselves, who could afford weapon systems but not internships, and that dovetails with my own thesis that these local elites are part of the problem. But I think the institutions, and I agree with Nilofer, the responsibility shouldn't be placed solely on the shoulders of the institutions. I think also the institutions can also do something. I once tried to help an intern from India who had to cut short his internship because he was running out of funds. And when I looked at the numbers, I realized the court pays for counsel, defense counsel and victims counsels if they can't afford one on their own. And let's face it, if you compare the lawyer's hourly fees with the needs of an intern, it doesn't take much to help an intern. So it is also a matter of the internal priorities of the institution, of the court in this case. But my last point is on the pipeline concept. There is also the challenge that for young lawyers and students from the globe, well, I will now use CHEA, the concept, the Global South, to enter the game. They would need credentials recognizable internationally, competitive internationally, and I will say most of the time, credentials from the West. So in terms of decolonizing international law, I think that's part of the battle. But to look at the positive side of things, I think there are in particular Asian states which have come up with programs that can produce credentials recognizable abroad. NUS, for instance, CHEA. When I was at the court, I will meet young European lawyers, young European professors who actually spent time at NUS, and love to speak of their experience at NUS. And so for us before, it was only it was a one-way street. Asians going to the West for credentials. Now we have people from the West coming to Asia for their own studies, for their own credentials, and I think that is a step forward, that we are now able to produce credentials within our region, credentials that will be recognized and respected outside.
Can I just add very quickly? I take this opportunity to promote the Center for International Law, because that's part of our mission, actually.
Oh, congratulations then.
It's to build that capacity. And I think the Asian Society of International Law as well. So these are institutions that really want to fill that capacity gap, and it is so important. So I had to throw that in.
I think that picking up on what Judge said, I think that there's also a lot of work to be done looking internally. So like even for academics and academic institutions from the Global South, we should be doing more to uplift each other rather than always looking at how we can match our KPI to the Global North, right? So I think that we also have to try to look at ourselves, even in academia, to rethink how we prioritize. I would love...
If I may just add, Nilofer mentioned the Asian Society. I sat on, eventually I co-chaired the academic and research program or committee of the society. And I'm happy to note, Chia, what you mentioned, that when we review the abstracts to be read during the conferences, and we'll accept the abstracts, I was pleasantly surprised that many Asian universities are now able to pay for their scholars to participate in international conferences. I thought that was something done only in the big universities in Europe and the US. And now Asian states and universities are able to do that. So I think these are this is signs of progress anyway.
Thank you. The next question is from my colleague, international law colleague, Tan Sien Lee. So given the disparities in power and perceived hypocrisy, how can Global South countries use the international rules-based order to exercise agency and protect their interests and well-being? So I can't remember who went first the last time.
I did last time. So
okay.
It's my turn then. It's my turn. Well, I can tell you what the Philippines did. We have this big tiff over the South China Sea with China, and we filed suit before the Permanent Court of Arbitration. And we won the case, and we believe, as our foreign secretary said then, the international law was the great equalizer. We couldn't have taken on such a big power in any other way except on the basis of law. And so the aspiration for a rules-based international legal order, I think, will be strengthened if there is increased recourse to rules-based dispute resolution. And I'm happy to note that well, the decision has been, although it's an arbitral award, has been widely recognized in many forums by many states. And so I think this is not an isolated phenomenon. At the ICJ, there is the Pulau Ligitan, Pulau Sipadan litigation. There is the White Rock case, the Batu Putih case of Singapore. There is the temple of Priya Vihar between Thailand and Cambodia. So even within our region, there are the like prime examples of recourse to rules-based dispute resolution.
Yeah, all right, I'll follow in. Yes, Xian Li, greetings to you. Indeed, that's a very good example that you gave, the South China Sea, and in the sense that international law institutions, despite what the issues of some capacity issues, but they are the equalizers. So the courts, I think we actually had Wheeling Recall based on Douglas Guilfoyle's book on small states and access to international courts and tribunals. And that, we look at small states, not necessarily all from the global south, but not the powerful states. So they're able to have a voice in international courts and arbitrations against powerful states. You mentioned earlier Nicaragua, ICJ, and there are other examples. But I would also add, and that's what I'm saying, General Assembly, the majority members of the General Assembly, I'm not saying Security Council because you have the P5 there, but the General Assembly are developing countries, or want to call them Global South, frankly. So it's really the question of using that system, and that's why I gave the example of the Pacific Island states, who have really used the UN system to protect their interests. And you see now Vanuatu brought the request for an advisory opinion. I will say this, that the questions of sea level rise and climate change, I think we owe a lot to them because they have been so vocal, persistent in this, and they are not powerful states at all. So a lot of it also has to do with priorities, use of the system, but again, we have to ask ourselves, does the Global South, do they all share the same interests? I don't think so. That's part of the problem as well. So that's why you have groups, and I know there's I think a question about region there. So yes, the Global South can, and we have plenty of examples of that, actually.
Thank you very much, and thank you to Prof. Tan for a question again. I'll now go on to the next question by David Devlomic. The presenters have both touched on the changing nature of the Global South and its relationship with international law. Judge Pangalangan touching upon sovereignty, and Prof. Oral on various concepts in international law that have developed due to the interests of developing states. He's wondering whether there's a regional approach to international law, and if so, what are its key components? Perhaps we can go back to the 5 peaceful coexistence or the outcomes of the Bandung Conference in the Asian region, but both of these are well over 50 years old at this point. I think that judge's turn, is it?
I'm going to start,
Okay.
Chair. Well, is there a regional approach? Well, I think the question came from David, right? David cited the 5 principles of peaceful coexistence. That was actually the proposal of Chou Enlai of China. He presented it in Bandung, and the final document used many points from the 5 principles of Chou Enlai. Will I consider that a regional approach? Well, China has presented it as the regional approach, but I guess that's again part of the dynamic, of the regional dynamic that that I mentioned of China having emerged as the big power in the region, and that has a sizable, an outsized voice even within the ASEAN, even within ASEAN discourse. But just to go back to the point, is there a regional approach? Well, the closest will be the, it's not good news, but it's the ASEAN unwillingness to confront, problems, human rights violations domestically. And if you characterize that as part of the regional approach, then it's not good news for international law. So maybe I'd rather not look for a regional approach and rather look for a truly genuine cosmopolitan international approach, and use that to prod Asian states to move forward.
Mm-hmm. I think I'm going to echo a bit, because that's what came to my mind was the ASEAN. That's probably one of the most, for this region. And of course, Xian Li, she's our expert and head of the ASEAN Law and Policy Program. I'm not an ASEAN expert, but there's a place for regionalism, but I think that really it's limited, and there's certain risks. I mean, I think of regionalism more, and again, it goes back to my area of ocean and seas, which does make sense, because there you have shared risks, shared influences specific to that region. But in terms of international law, there's a debate about regional customary international law. Of course, you have EU, that's the big region, and the EU clearly has its own approach. But I'm not sure we could say its own approach to international law per se, except maybe human rights. But I think I would agree with Raul that we should really keep at the cosmopolitan, it should be at the international global point, because regionalism can also lend to what we always refer to the issue of fragmentation. And we certainly don't want that. We don't want competing norms. I think the idea is to have common norms, common understanding. It's just the question of whose understanding is dominant. And I think the concern is that it has been dominated by the global north. Well, what are those norms that have dominated the norms? Human rights? Is that bad? I don't know. I'm just thinking out loud. So that's why I'm wondering, again, what are the values that the global south would like to see expressed as part of its idea of international law?
Thank you. The next question is from Niroshika. Dear Prof. Aurel, thank you very much for your insightful presentation. How do you see the involvement of multinational corporations and their influence in making weaker states in the global south become more vulnerable? What could be the possible options to create direct obligations on MNCs in international law? So maybe first Dr. Aurel and then Judge.
Yeah, okay.
Yes, that is really a really good, excellent point. And I think one of the great weaknesses we have in the system. The truth is that multinationals exert enormous power and influence, disproportionate. And because they're private, they don't quite fall under that umbrella of, international law per se. And I mean, we can take so many examples, of course, the big energy companies. So this is now, I mean, there's obviously emerging the whole idea of human rights in corporations. We just did something in the International Law Commission, very important, although soft law, on protection of the environment in relation to armed conflict, which for the first time included private companies to have responsibilities as well. But here's the issue. Even though the multinationals are global north, unfortunately, they are also protected by some of those interests, and I think this is the domestic aspect, interests who benefit from the multinationals within the global south countries. So it goes both ways, but absolutely, I think this is an area that needs to be strengthened. There are developments, obviously these, but it's all soft: global compact, social responsibility, whether it be human rights, environment. I'm just thinking about, because the famous Chevron case on Ecuador, and it's just egregious example of where the company goes in, they win. The lawsuit is brought in Ecuador, brought by indigenous peoples whose land has been harmed, poisoned by the oil company. But that lawyer who brought the case back in the States, he's persecuted under a U.S. law. And so how do you tackle that? Very difficult when you have U.S. laws actually working against other countries' interests as well. So I'll stop here. I'll go. I feel like I may be going on a tangent a little bit, but it is such an important issue. And Raul, you can go next.
Oh, thank you so much, Nilofer. Well, Niroshika, thank you so much for the question. In fact, your question captures the dilemma that I want to focus on. So, for instance, in the experience of my country, the Philippines, in terms of respect for the environment, it is the foreign mining corporations which are well behaved, because they have to live by the environmental standards of their own home state, and the miners who use primitive methods, like the most primitive is to use mercury in mining, are actually the local small scale miners who are able to operate free from all the big regulations. So we confront the dilemma there. It is a corporation regulated by the strict standards of the global north, which satisfy global standards on environmental safety. The same thing with anti-corruption. The strict foreign corrupt practices rules are promulgated in first world states. If they are prosecuted there, then it is fearsome. If they are prosecuted domestically, then they can buy their way out. So again, it is the problem that I mentioned, that the traditional bad guys are actually the good guys when it comes to this problem. And just my last example, social labeling, sweatshop free garments, dolphin safe tuna, child labor free soccer balls. Where are the violations committed? Typically in the global south, by global south operators. Where are the sanctions? The sanctions are in the consumer markets in the global north. And again, the formula is reversed. So I think, well, this is at the heart of the business and human rights focus. But for me, the question of Niroshika sort of brings to the surface the dilemma that I mentioned about the north-south divide taking a different shape today. Thank you.
Thank you very much. The next question is from Rafael Pangalangan.
Oh, I think I know that fellow.
Yeah. So it's to Prof. Raul. It's interesting to frame global south rhetoric as a matter of values, which to me resembles a term that preceded the global north, global south divide, Asian values. But isn't global south more descriptive than normative, a name given to the common thread of colonial history? What benefits are there in reintroducing normative language? So maybe first Prof. Raul and then Judge.
Well, thank you so much for that question, Raphael. I think I only, what is the global south? Is it just descriptive? But when we talk about decolonization of international law, what does that mean? And my understanding, of course, that when we speak of decolonization, this refers to the global south. And so what does the decolonization process entail? What are the values? And so that's what I'm asking. I'm not wedded to global south, but it seems to be linked to this notion of decolonization of the current international law system, which is seen as being, of course, highly influenced by colonialism, and absolutely. But I just want to I hope I'm not misquoting, but recently Tony Angie was in a panel at the UN on this issue of global south. And he made the point of how, yes, international law, very much the product of the colonial powers and history, but maybe it's time now for that global south to make its own history. And I guess that's what I'm also asking. What is that history that the global south should be making? Usually what I hear, it is more to do with economic development, but is that it? Is there something more to it? So it's not rhetorical. I really would like to know. So thank you for that question, Raphael. I don't know if I answered it, but let's see what Raul has to say.
Well, first of all, I'd like to congratulate Raphael. He just won an award as the young lawyer, outstanding young lawyer of the International Bar Association.
Bravo.
Congratulations.
Fantastic. Congratulations.
Congratulations.
Raphael, that is exactly why I earlier expressed hesitation about the regional approach, because then that is the umbrella under which we have the Asian values debate. And the history of the Philippines attests to that problem. When Marcos was accused of human rights violations under his emergency rule, his favorite line, and it was quite a powerful line, was that we interpret human rights differently here in Asia. And the West's priority for freedom of speech must give way to his economic development activities. And so we ended up unfree and still hungry. And so that is the tragedy of the trade-off debate. That's all I can say.
The next question we have is from Ajay Nair. Dear speakers, thank you for your remarks. As was raised during the presentations, in an area such as climate change, international law has recognized that state responsibilities are differentiated by the extremely unequal histories of environmental exploitation. Moving forward, do or can other areas of international law develop such a nuance that distinguishes obligations in light of the economic exploitation experienced by post-colonial states? Maybe Judge can go first, and then Dr. Aurel.
Well, as I earlier stated, Ajay, when it comes to the legacy of colonialism and the legacy of the environmental costs of earlier colonial depredation, I think for that issue, the old formula will still hold. And that much of that depredation happened during the colonial years. We are paying the price today, and that they who benefited from that depredation should bear the cost of. And so the nuanced approach that you asked, that you mentioned, I think is valid for this. And Nilofer, is the expert in this field and has given us the concepts by which international law tries to take into account the textured treatment and allocation of responsibility for that damage to the environment. Nilofer.
Yeah, thank you so much, Ajay, for your question. Indeed, we see that the differentiated responsibilities is being or wanted to be applying different areas, such as, for example, in WTO. It's a big debate now. I was involved in a project actually on that. And there, of course, the question is whether, the concept of equal treatment versus common but differentiate responsibilities. It also this came in within the International Maritime Organization, which also shipping, the notion of shipping, also everyone's supposed to be equal, but when it comes to climate change, does it automatically kick in? And that's the question, because of that historical responsibility. So we are seeing it. And the reason is that climate change is increasingly becoming a cross-cutting issue. It's entering everything. So climate change includes common but differentiated responsibility. And the question then is whether common but differentiated responsibility is actually a general principle of international law that applies overall. However, we have to be careful. And I think, again, not all developing countries at the same level. And who makes that distinction? And I'm not sure how we apply it. And I think that's one of the challenges is how it's applied. But anyway, so just a quick response to your very good question.
I think we only have time for one more question. So Rashmi Raman is asking about asking speakers to speak about the reticence of the global north to actively push the powers of the the so-called reticence of the global south to actively push the powers of the global north in dispute proceedings. And Rashmi talks about Prof. Chesterman's characterization of this as the Asian ambivalence to international law as particularly important. So maybe Dr. Aurel, you could go first, and then Judge.
Okay. So, well, there are various reasons why the global south, or let's say developing countries, may be reluctant to take the global north. One, of course, international dispute proceedings, you need to have agreement of both parties, so that may be a problem there. Costs also, politics, of course. And I'm going to give the example, this had to do 10 years ago, Palau was going to bring proceedings on climate change to the International Court of Justice, but the United States heavily pressured them against it. And who knows, what pressures they use, economic, political. So there are a lot of, in the background, many factors that could prevent that. But on the other hand, we do see that they do use the international legal system at times. So I'm not sure it's necessarily always ambivalent. I can't speak for Asia, though. Asia, of course, we talk about non-confrontational approaches, whether that's it, more trying to mediate, and maybe Raul can speak to that better than I can.
Well, just 2 points. When Professor Chesterman speaks of Asia's ambivalence to international law, it is so real for me, because in the ICC, Asia is the least represented region all over the world. And in fact, if you look at the international legal community's responses to the Russian invasion of Ukraine, whether it is in terms of the votes at the UN General Assembly or the interventions at the ICJ in the Ukraine versus Russia case, or at the ICC, the referrals, the state referrals of the Ukraine investigation, of the referrals to the office of the prosecutor. The Asian states, the absence of Asian states is so conspicuous. I have written a paper on this. If you look at the numbers, it's really appalling. So it is actually, for me, the question is it because we don't share the norms? I think we do. Maybe it's we don't share and we are not enthusiastic about the legal forum in which it is done. In other words, the ambivalence is not because it is international. When it comes to the ICC, for instance, the ambivalence is because it is a court, and which goes back to the cultural element that Nilofer mentioned earlier, the hesitation to submit to binding third-party resolution. So for me, the Asian ambivalence point is highlighted by our lack of participation in many of these mechanisms. For me, on the more anthropological side, maybe it is also because, and this is, I will close with this point, we project onto the ICC our own perceptions of our own domestic courts. So if local judges are vulnerable, we expect ICC judges to be vulnerable. If the prosecutors are so beholden to politics, the same thing. And so it is the projection of domestic flaws onto the international stage. So which brings which reverses the formula then, that maybe if we want to promote respect for the rule of law internationally, we should promote respect for the rule of law domestically. In other words, we should teach local jurisdictions how courts should operate, how prosecutors should do the prosecuting, how investigators can actually build their evidence without violating human rights. I'll close on that point.
Thank you so much. It's actually very hard for me to stop taking questions and to bring the seminar to a close because both speakers have shared so much. And I actually had a list of questions prepared and I didn't even get to use it. So we'll just have to organize a follow-up seminar so I can ask my questions. So thank you once again to our amazing speakers. Thank you to the CAL staff, Momoka, for organizing this. Thank you to Prof. Hoffman for the welcoming remarks and to Prof. Jacqueline Neo for facilitating this. And most of all, thank you to our audience for all the incredible questions. You have left us all feeling very encouraged and inspired. So thank you. And thank you once again to our speakers and have a great evening to everyone. Bye.
And thank you.
Thank you so much, Chair.
Okay, thank you.
Bye. Really wonderful. Thank you so much. Bye.
Bye-bye.